Hi, I'm Lucas Morel, the John K. Boardman Jr. Professor of Politics and head of the Politics Department at Washington and Lee University in Lexington, Virginia. I'm also a visiting teaching fellow at the Kirby Center, the School of Government in Washington, D.C. for Hillsdale College. Welcome to this symposium on race in America. I'll be speaking today on a colorblind constitution. Abraham Lincoln once said that the central idea of American public opinion from the beginning was the equality of men. The problems, of course, arose when the idea was undermined by the continued practice of racial slavery as it was defended no longer as a necessary evil, but as a positive good, if you can believe it, good for the master and the slave. Even though the defenders of slavery were defeated in the Civil War, white supremacy still reigned throughout the South well into the 20th century. And so a nation that began as the first in human history, devoted to the self-evident truth that all men are created equal, still wrestles with the role that race should or should not play in government policy. Put simply, should Americans govern themselves in a colorblind fashion when it comes to the rule of law? Or should we use race to try to eliminate the lingering effects of racial slavery and segregation? Put simply, should Americans govern themselves in a colorblind fashion when it comes to the rule of law? Or should we use race to try to eliminate the lingering effects, the legacy, as they say, of racial slavery and segregation? One of the greatest American orators of the 19th century, this gentleman, an escaped slave and abolitionist orator, Frederick Douglass, began his public career criticizing the United States Constitution as a pro-slavery document. Douglass asked, "What country have I? The institutions of this country do not know me. They do not recognize me as a man." And so he concluded, "I have no love for America." To his credit, and this country's, he did not hold that position for long. He eventually claimed America as his country, calling the principles of the Declaration of Independence saving principles, and the Constitution no longer as pro-slavery, but a glorious liberty document. He found that reading the Constitution the way his former mentor, William Lloyd Garrison, read it, as a pro-slavery document, contradicted its preamble and gave short shrift to the many levers of freedom found therein. He also noticed that the Constitution actually never mentioned the words slave or slavery or race, and it permitted the Congress to actually ban the importation of slaves as early as 1808, which they actually did. He said, therefore, that it leans to freedom, not slavery, and looked to the abolition of slavery rather than its perpetuity. Planting his political identity firmly in his citizenship, it led this former slave, who had every reason to hate America, to become one of her greatest defenders. On the question of race in the Constitution, Frederick Douglass was clear, quote, "Color should not be the criterion of rights," end quote. He also said, "I know of no rights of race superior to the rights of humanity." When asked what he would do if he were president of the United States, after he stopped laughing because that was absurd at that time, he knew it would never happen, he replied, "I would secure to every citizen of the United States, without regard to color or sex or religion or race, equal protection of the laws. If all men are created equal, then their government should protect them equally, secure what each member of the political community possesses equally, namely, their natural rights." Douglass's plain reading of the Constitution and the Declaration of Independence led him to conclude that blacks should not be made an exception in the law. This would reinforce the stereotype of racial inferiority and undermine the central idea that all men are created equal. Douglass always considered the impact that public policy would have on how whites treated and viewed Black Americans. And therefore, he didn't favor any government practice that would relieve Black Americans of any duty or responsibility that was expected of all other Americans. "We do not solicit unusual favor," he said, "but will be content with rough-handed fair play." He went on to add, "We are neither lame or blind that we should seek to throw off the responsibility of our own existence or to cast ourselves upon public charity for support." But as much as Douglass did to promote the elevation of blacks in America, he actually was not a fan of what we would today call race pride. He called it a false foundation and a positive evil. He proclaimed it the very thing we're fighting against. For most of American history, Black Americans wanted nothing to do with a color line that separated them from the rest of the American population. He wrote that it was our enemies who sought to, quote, "deepen and widen the line of separation between the white and colored people of this country." Given that blacks were a numerical minority in the United States, racial solidarity was never the key to gaining greater security and protection of their civil and political rights. His argument against race pride led him to criticize what he called complexional institutions. Over a decade before Lincoln was elected president, Douglass argued, quote, that all distinctions founded on complexion ought to be repealed, repudiated, and forever abolished. Every right, privilege, and immunity now enjoyed by the white man ought to be as freely granted to the man of color. He thought that, for example, colored conventions, as they called it then, colored exhibitions, colored associations and institutions, he said these are hindrances rather than helps in achieving a higher and better estimation for the black man in the public mind. His concern for the impact of public policy on public opinion led him to argue against any recognition of race or color when it came to government policy. It's safe to say that Douglass was not a practitioner of identity politics. So, have the American people ever adopted Douglass's clear belief in a colorblind constitution? After the 14th Amendment was ratified, just a few years after the end of the Civil War, the Supreme Court began to decide cases involving equal treatment under the law. One of the key clauses of the 14th Amendment requires that no state shall, quote, deny to any person within its jurisdiction the equal protection of the laws, end quote. This would seem to ban any government use of racial classifications. But unlike Douglass, who did not believe race should be the measure of anyone's constitutional rights, to this day, the Supreme Court has never adopted or interpreted the Constitution to be a colorblind constitution. Instead, it has reserved to itself the authority to decide when government use of race is constitutional and when it is not. Ironically, it was a lone dissenting opinion that introduced the concept of a colorblind constitution. However, that dissenting justice was outnumbered by 7 justices who interpreted the Constitution to permit government use of race as long as it was done in, as they call it, a reasonable fashion. What was later known as the rational basis test permitted large discretion on the part of state governments to employ racial classifications to promote the peace, safety, and comfort of the community. That case was Plessy v. Ferguson, an 1896 ruling that gave us that the notion that separate but equal was all right. It was an acceptable measure of whether one's race was being used in a constitutional way by state government. This pernicious standard was precedent for subsequent cases until the landmark decision in Brown v. Board of Education of Topeka, Kansas in 1954. It ruled unanimously that racial segregation of public schools deprives students of, quote, the equal protection of the laws guaranteed by the 14th Amendment, end quote. The NAACP, the National Association for the Advancement of Colored People, they provided the lead group of attorneys in these cases. Their in-house legal defense fund, known as the Fund, had for decades not attacked segregation laws directly, but had argued, and argued successfully, that segregation was unconstitutional because it did not apply equally to citizens of all races. They adopted this strategy early on because of the precedent of separate but equal, the separate but equal doctrine established in the 1896 case of Plessy v. Ferguson. So the NAACP contested legal segregation not by arguing that it itself was unconstitutional, but only if they separated citizens according to race in an unequal way. The idea was to make segregation too expensive, especially for southern state governments to maintain. If a state provided a public park, a library, a pool, a golf course, but only did so, it was public, but only did so for whites, but it didn't provide one equally for black citizens, or they provided one of inferior quality, the NAACP would say, this violates the 14th Amendment, which says, again, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. In case after case, in the first half of the 20th century, the NAACP won court case after court case in the highest court of the land, using this strategy, showing that racial segregation was never applied or not applied equally. And it forced states to provide equal accommodations or, if they lacked the funds, to eliminate the segregated facility altogether. Well, the problem was that after a while, southern states that had been segregating but could not afford to do so on an equal basis, they just decided to close it all down, close the public facility rather than desegregate them or provide an equivalent one for black citizens. More importantly, in terms of the jurisprudence that the NAACP was pursuing here, with each victory, they were actually reinforcing legal segregation by reinforcing the precedent of separate but equal that was established way back in 1896. So by the 1940s, the Legal Defense Fund finally decided to attack segregation head on, and they invited the Supreme Court to overturn its decision in Plessy. Now, this is was a risky strategy given how much the High Court likes to stick to previous decisions. They don't like to admit that they were ever wrong, especially precedents that had been on the books for so long. In all 4 lower court cases dealing with segregated schools, the courts had followed the Plessy doctrine of separate but equal. They ruled that if the conditions of the schools were basically equal, the Constitution was not violated even if the educational outcomes, the results of that segregated education, were unequal. Why were the lower courts so focused on the inputs, for example, buildings, curricula, qualifications of the teachers, their salaries, rather than the effect that segregated or separate but equal conditions were having on children? For this, we have to go back to the court's reasoning in Plessy. So some quick facts about the Plessy case. Homer Plessy was 7/8 Caucasian and 1/8 African blood, as the testimony said, though the Africanness, if you will, was not discernible. You couldn't tell by looking at Homer Plessy that he was part black. He deliberately rode in a railroad car in Louisiana that was only traveling within the state of Louisiana. He deliberately rode in a car for white passengers and actually had to tip the conductor to the fact that, oh, by the way, I'm 1/8 black. So this was a contrived case. He did this deliberately so that this could be thrown into court. So Homer Plessy, a local citizens committee, actually worked with the railroads because they thought it was expensive to segregate. They didn't want this either. So they worked to try to get this case to the Supreme Court, which they did. You have to remember at this time, even though he was 1/8 black, this country was operating under what's known as the one-drop rule. So it didn't matter how Caucasian you were. If you had one drop of a particular other race or ethnicity, that's what they counted you as. And this, you could trace this back. Agree, Florida had a one-drop rule all the way back dating to 1866. An important part of the Plessy case was the text of the 1890 Louisiana Statute that required separate railway carriages for whites and what they called the colored race. And this is what the text says. that all railway companies carrying passengers in their coaches in this state shall provide equal but separate accommodations for the white and colored races by providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure equal accommodations. And it added, and this is very important, no person or persons shall be admitted to occupy seats in coaches other than the ones assigned to them on account of the race they belong to. Justice Brown interpreted the Equal Protection Clause of the 14th Amendment, quote, to enforce the absolute equality of the 2 races before the law, end quote. However, he read this to mandate equality of treatment, not equality of outcome or social or public perception. Just because whites must sit in this railway carriage and blacks must sit in that railway carriage, he says this does not impose a badge of inferiority on either race. Moreover, state legislatures, he said, had long been allowed to separate the races in public venues as part of their traditional, what is known as police powers. Justice Brown gives the example, actually, of segregated schools, even in the states where the rights of blacks had been, quote, most earnestly enforced, end quote. So this was a longstanding practice. Justice Brown gets to the crux of the issue when he says the case comes down to whether the statute of Louisiana is a reasonable regulation. His answer? There must necessarily be a large discretion on the part of the legislature, which he argues is at liberty to act with reference to established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. Now, all of this, of course, was a euphemism for maintaining the status quo, which, of course, was white supremacy. Given this practice, the court concluded that, quote, we cannot say that a law which authorizes or even requires the separation of the 2 races in public conveyances is unreasonable or more obnoxious to the 14th Amendment than the acts of Congress requiring separate schools for colored children in the District of Columbia, the constitutionality of which does not seem to have been questioned, or the corresponding acts of state legislatures, end quote. So this reasonableness standard, or what we now call the rational basis test, it actually is the lowest threshold for state action to be considered constitutional or unconstitutional, especially under the 14th Amendment's Equal Protection Clause. So the court therefore allows large discretion by the states if they employ, at that time and for decades, racial segregation when regulating public interaction between the races. But what if racial segregation produces a perception that one race is inferior to another, right? A badge of inferiority. Justice Brown addresses this directly in a passage that Chief Justice Earl Warren will later reject to arrive at the opposite conclusion. And this is 60 years later in the Brown case. So here's what the Plessy court concluded. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the 2 races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act or the statute, but solely because the colored race chooses to put that construction or that interpretation upon it. In other words, any feeling of inferiority as a result of racial segregation is not the product of government policy, as long as that racial policy is equally applied. The court's separate but equal doctrine does not actually make any citizen inferior. Therefore, if someone does feel inferior because of racial classification, that's because that person chooses to interpret it that way. In the one dissenting opinion, the opinion of Justice John Marshall Harlan, he thinks that this reading of the statute is absurd. Everyone knows that this law and other segregation laws are intended to maintain a legal or at least a social hierarchy of whites over blacks. He also doesn't think courts especially the Supreme Court, should inquire into the so-called reasonableness or wisdom of state legislatures. The only question the Supreme Court should try to answer, he thought, was, does the state law comport with the Constitution? And in this case, it's the Equal Protection Clause of the 14th Amendment. In his mind, the court recognizes no caste or superior ruling class of citizens. He then cited a concept that was actually first presented at oral argument by the lead attorney for Homer Plessy, and that was a guy named Albion Tourget. At oral argument, he observed, quote, if justice is pictured blind, then the law, at least, should be colorblind. Here's how Justice Harlan put it in his dissent. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. He added, the law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land. So, given so many subsequent cases that relied upon Plessy as precedent, how did the Warren Court in 1954 rule unanimously to reject the separate but equal doctrine? In its short, I think it's 9 pages, plainly written ruling, the new Chief Justice, Earl Warren, argued that Americans in the mid-20th century now lived in a different world than that of the 1896 Plessy Court. Most importantly, education was now a leading function of state government. It was now compulsory, supported by a substantial budget, and had become, as Warren put it, the very foundation of good citizenship. So if the state became the educator of its citizens, then it was responsible, according to Warren, not just for the educational inputs, but for what those inputs produced, the educational outcomes. Such an opportunity, Earl Warren said, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. To get around the Plessy doctrine of separate but equal, Chief Justice Warren leaned on more recent precedents, Sweat v. Painter and McLaurin v. Oklahoma, 1950, to include what he called intangible considerations in the educational process. Not just inputs, material ones like buildings or teacher qualifications, things you could measure, but also the learning environment, and this is key, what that environment produced, the results. As he put it, we must look instead to the effect of segregation. Segregation itself, its effect on public education. He concluded that to separate children from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. So when government segregates children according to race, and this separation produces feelings of inferiority, then government is now responsible for that outcome. It's not simply an interpretation or construction that children choose to put on their racially segregated school. The court ruled that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Now, few court observers disputed the decision, the result in this case, but many questioned the reasoning, especially its reliance upon psychological tests to determine the effects of racial segregation upon segregated students. To decide if the Constitution was violated by a government use of race on the basis of feelings generated seemed like a dubious basis for determining if a person's rights under the Constitution were infringed. Think about it. What if a segregated school didn't generate a feeling of inferiority? Would there be no violation of the Equal Protection Clause of the 14th Amendment? And if not, did Brown actually overturn Plessy? Now, if Brown decided that government could not pay attention to race, couldn't separate students on the basis of race in K through 12 schools, public schools, the second case involving education ruled that government could use race in higher education, not to separate, but to promote diversity, what they call the educational benefits that flow from a racially diverse student body. So we now shift our discussion of government use of racial classifications from segregation or desegregation to the policy known today as affirmative action. It should go without saying that using race in a constitutional way means you're not operating according to a colorblind constitution. We'll see how the Supreme Court justifies this under the 14th Amendment's Equal Protection Clause. The key case is actually two cases in 2003 involving the University of Michigan, their law school and their undergraduate university. They're the cases of Grutter v. Bollinger and Gratz v. Bollinger, respectively. Now, the Supreme Court upheld affirmative action as it was practiced in the law school, but it rejected affirmative action that operated differently at the undergraduate university. The key precedent for Justice Sandra Day O'Connor, who took all the Supreme Court affirmative action cases when she was on the court, her key precedent was a case that had been on the books for 25 years, the 1978 case of Regents v. Bakke. Unlike the Brown decision, which only relied on the 14th Amendment back in 1954, O'Connor's opinion drew from two provisions of the Constitution, and in this she was following Justice Powell in Bakke. The Equal Protection Clause of the 14th Amendment, for sure, but also, because it dealt with higher education, the Free Speech Clause of the First Amendment. Reasonableness or the rational basis test was the prevailing court standard until about World War II, when two cases dealing with Japanese internment, the Hirabayashi case in 1943 and the Korematsu case of 1944, these led the court to adopt a new, more rigorous measure of constitutionality when it came to race. Racial classifications by government were now considered by the court immediately suspect. They weren't categorically unconstitutional. They've never ruled that. But they were immediately suspect and subject to, as the court put it, the most rigid scrutiny. So they're moving off of reasonableness and ratcheting it up a bit. This is now known as the strict scrutiny test. And it's a test that has two prongs, both of which have to pass in order for a government use of race to be considered constitutional. Number one, it has to serve a compelling state interest. It has to be a priority of the state government, and that also includes the federal government now. Secondly, it has to be narrowly tailored to meet that state interest. So you have a constitutionally permissible end that you're looking for and a corresponding constitutional means to securing that end if you're using race. So at the University of Michigan, affirmative action was used, again, one way at the law school and another way at the undergraduate university. The difference between the two policies produced the different outcomes, as O'Connor and then Rehnquist in the Gratz case applied strict scrutiny. So what were they doing at the law school? They were looking at students according to race, especially those that they considered underrepresented minorities. We'll use the acronym URM. Okay, so they would favor URMs to produce what they called a critical mass or meaningful representation of Blacks, Hispanics, and Native Americans. And if you listen to the oral arguments, I remember being on the Interstate 66 on my way to DC and actually listening. I think this is one of the first court cases where they actually, I think this was on NPR, they actually let you listen to what was actually being said. The Michigan attorney was fantastic. Whatever they paid her, they should have given her a raise because Scalia and the conservative justices were leaning in on her. They were trying to see if they could say that that Michigan was employing a quota. And they said, critical mass. Could you define critical mass for us? And she said, yeah, meaningful representation of URMs. And they're like, what's meaningful representation? So if she used an absolute number or a fixed percentage or a narrow band that they were looking for, they would have lost. Even the liberals on the court would have said, you can't do that. You know what she did? She just said, critical mass. She just bounced back and forth. Critical mass, meaningful representation, until the justices gave up. So, critical mass. Second, the state of Michigan argued that it had a compelling interest to diversify the student body in order to enhance the education of its law students. So, how do you get educational diversity? Free exchange of ideas. You can use race to help promote that. Lastly, it claimed that its pursuit of a critical mass was not a quota, which had been disallowed in the precedent of Bakke 25 years earlier. Now, because the case dealt with higher education, right, colleges and grad schools like law schools, Justice O'Connor drew from Powell's Bakke opinion to argue that not one but two constitutional provisions, as I mentioned earlier, needed to be balanced or reconciled to determine if the law school's use of race was justified. Now, we've got the Equal Protection Clause, which I'm sure you're tired of me mentioning, but they're all over it. You have on the one hand the Equal Protection Clause of the 14th Amendment, but then you also have the First Amendment's Free Speech Clause. Now, why? Courts have long treated colleges and universities as a special niche in constitutional adjudication. The nature of education, they believed, requires academic freedom. And so, what do they say? They respected the university's need, the law school in this case, to determine how best to promote the exchange of ideas necessary for the education of their students. If racial diversity could help in this regard, the court was not going to second guess. This is important. They were going to defer to Michigan's educational autonomy, as they called it, as it pursued what they considered to be a compelling state interest. Even though you've got this constitutional requirement that no state shall deny to any person the equal protection of the laws. So in satisfying the first prong of the strict scrutiny test, let me make a few observations about O'Connor's reasoning. First, she presumes, and she calls it this, she presumes good faith on the part of the university when it claims that, hey, we're only using race to promote this educational end. Now, what's interesting about this, if the court is deferring to them, if you will, granting them large discretion in its use of race, doesn't that sound an awful lot like Justice Brown's reasoning in Plessy? Second, because the Bakke precedent from 1978 ruled that redressing historical wrongs, the thing that you would think affirmative action would be all about, Justice Powell said, no, you can't claim that your specific affirmative action policy is going to redress or provide a remedy for historical harms that were done to racial minorities. So he actually said, you can't justify racial classifications by saying, well, we're trying to repair the damage of previous discrimination. The only purpose for Powell, and O'Connor borrowed this, the only purpose that passed constitutional muster was racial diversity as a means of promoting educational diversity. What's curious here is Michigan provides a counterintuitive explanation for its promotion of diversity. Here it is. They argued that they needed to include more underrepresented minorities to break down stereotypes. You don't want to have a token Native American or Black person or Hispanic in class, because otherwise the majority white student body would think, oh yeah, that's the way all Blacks think. In short, you see what they did? Affirmative action is justified not because it helps racial minorities, but because it helps the white kids. That's an interesting turn of events. What O'Connor called effective participation, she saw was promoted by a law school that enrolled a sufficient number, right, meaningful representation of URMs. This showed, in her mind, the path of leadership being visibly open to talented and qualified individuals of every race and ethnicity. And although O'Connor claimed that race was not to be understood as a proxy for a specific way that all members of that race thought, a critical mass of URMs lets the law school demonstrate, right, visibly, that it is training a diverse group of attorneys and therefore leading to the enhancement of the integrity and trustworthiness of those who will eventually assume roles of leadership in the nation. Now, satisfied the first prong of strict scrutiny, what about that narrowly tailored part? We're moving from ends to means. The 14th Amendment protects, and O'Connor is a stickler for this, it protects individual persons, not groups. Therefore, affirmative action that is constitutional must ensure what O'Connor, again drawing from the Bakke opinion of Powell, called individualized consideration. Any policy that amounts to a racial quota, we're just going to set aside a certain number of seats, or like a dual track admission system, or any other sort of mechanistic treatment of applicants, doesn't treat each applicant as an individual person, and therefore in her mind would violate the Equal Protection Clause. While race can act as a plus, it cannot be what she called the defining feature of a person's application. O'Connor's majority opinion in Grutter v. Bollinger was a split decision, 5 supporting affirmative action at the law school and 4 arguing to reject it. That's a pretty tight, pretty close decision. So this made, though, Grutter stronger than Bakke, because that Bakke precedent was peculiar in the sense that Powell had an opinion that no other justice joined. And you're like, well, how could that be the precedent? Well, 4 justices agreed with part of Powell's decision or reasoning, and 4 other justices agreed with a different part. And that's how Powell's opinion became the precedent, even though it wasn't technically a majority opinion. Then Chief Justice William Rehnquist, he dissented in the Grutter case, arguing that the close parallels between the percentage of URMs who applied and the percentage who were accepted in any given year, year over year, proved that the law school was in fact employing a quota to reach its critical mass of racial minorities. In other words, it was looking to see, well, how many out of the whole pool applied? Okay, we need to make sure roughly that many get accepted. And so he says, man, this is an obvious failure of the narrowly tailored test. They're not being treated as individuals. As for the undergraduate university use of race in admissions, the Gratz v. Bollinger case, the Supreme Court ruled that by awarding 20 points automatically to every URM applicant, the university did not treat them as individual persons, and therefore they were using race in a way that ensured their acceptance. Rehnquist wrote the majority opinion in Gratz, but he had to follow the Grutter precedent in order to reach his conclusion, and it was a conclusion that O'Connor joined, and so that was a 6-3 decision. So to wrap things up here, Frederick Douglass devoted his adult life to getting white Americans, as he put it, to trust the operation of its own principles. Or as King put it, all we ask is that you be true to what you said on paper. That paper was the Declaration of Independence and the Constitution, which King viewed as a promissory note to which every American was to fall heir. A colorblind constitution would seem to be a logical implementation of the colorblind ideals of the Declaration of Independence. But the Supreme Court essentially has left us with 2 conclusions about government use of racial classifications under the Constitution. Number 1, government can't pay attention to race when it involves assigning students to public schools at the K through 12 grade levels. Number 2, government can pay attention to race if it involves colleges and graduate schools like law schools and their exercise of academic freedom in pursuit of the educational diversity that flows from racial diversity. In the end, as long as the Supreme Court continues to apply a strict scrutiny test to determine if affirmative action or any other race-based program, whether in college admissions, hiring and promotion, or awarding government contracts, a colorblind constitution is nowhere in sight.